Hi, my name's Isaac Shutt. I'm an estate planning attorney. I'm licensed to practice law both in Texas and in Wyoming. And in this video, I'll answer an extremely popular question, and that is, what happens to my power of attorney when I die? Well, there's an easy answer to that, so I will keep this video really short. The answer is, when you die, the power of attorney dies with you. So frequently what happens is somebody comes into our office and they've lost a relative. Oftentimes it's a parent. So mom or dad has passed away and the child comes into our office all up in arms saying, "The bank is so wrong. They won't talk to me. They say my power of attorney is no good, even though they've been honoring this power of attorney for years." Well, then our question is that because your parent is passed away? Well, yeah, they've passed away. Okay, well, the power of attorney ceases to have its power once the grantor of that power of attorney passes away. So in that situation where that prospective client is all up in arms because the bank won't let them into the deceased person's bank account, the bank was actually right not to let them in because the power of attorney no longer has any force and effect. And so the power of attorney doesn't give that person the authority to access that bank account anymore. So there you go. There's the real short answer to the question, what happens to your power of attorney when you die? The power of attorney dies as well. It no longer has power after you pass away. And I hope that that means you will have something else like a joint tenant with right of survivorship designation on your account. You've got a trust, or at a bare minimum, you have a will. Oh, by the way, I should mention one last thing. The bank often will find out that you've passed away automatically. So just because you think that, I'm listed as the power of attorney, I'll be able to access mom or dad's account after they pass away because they won't know that mom or dad has passed away. I wouldn't count on that. Oftentimes, the bank will already know of your loved one's death, and they can find out automatically through the Social Security Administration. The Social Security Administration maintains a database that has all the deceased people's Social Security numbers in it, and so basically that account will be flagged automatically when your loved one passes away, because under the law, the funeral director is required to notify the Social Security Administration. Social Security Administration adds that number to the master index, which is the list of all the people's deceased Social Security numbers. And so that's how the bank will automatically know that your loved one has passed away, even if you don't tell them. So it's not like you're probably going to be able to go into the bank with your power of attorney after the loved one's died and think, hey, the bank doesn't know that she's died, so I'll be able to get one over. The answer is probably you're not going to be able to do that because the bank probably already knows that your loved one has passed away and it's probably gone ahead and frozen those accounts. So it's probably time to go see an attorney about doing that will probate or doing the trust administration or whatever. So anyway, I hope you found this video helpful. If we can be helpful in any other way, we would love to hear from you. Our contact information is down below. My name's Isaac Shutt. I'm an estate planning attorney licensed to practice law both in Texas and in Wyoming.